Good morning, everyone. I'm Tom Fitton. I'm president of Judicial Watch. It's Tom Fitton, F as in Frank, I-T-T-O-N. Joining me on my left is Bob Popper, and on my right, Chris Fideli, both of whom are attorneys with Judicial Watch. Judicial Watch is announcing today that today it sent letters to top election officials in Iowa, Colorado, and the District of Columbia, warning that it will file federal lawsuits against each state, or in the case of the District of Columbia, the district, within 90 days if they fail to take immediate actions to comply with Section 8 of the National Voter Registration Act, or NVRA, sometimes known as the Motor Voter Bill, requiring them to maintain accurate lists of eligible voters. The organization also sent inquiries to officials earlier this month in California, New Mexico, Kentucky, West Virginia, North Carolina, Alabama, Mississippi, Missouri, and Illinois, notifying them of potential apparent problems and asking those states to provide records of steps taken to assure the accuracy of their voter lists. But the letters to the Secretaries of State in Iowa and Colorado and to the Board of Elections Supervisors in District of Columbia specifically warn that we write to bring your attention to violations of Section 8 of the National Voter Registration Act. This letter serves as a statutory notice that Judicial Watch will bring a lawsuit against your office if you do not take specific actions to correct these violations of Section 8 within 90 days. In each state and the District of Columbia, the letters advise the election officials of specific evidence gathered by the organization indicating that the jurisdictions are failing to comply with the voter registration list requirements under Section 8 of the NVRA. Specifically in Iowa, we compared 2010 census data and 2012 census data was data presented in 2010 and 2012 to the Federal Election Assistance Commission, and it shows that there were more people registered to vote than there were adults over the age of 18 living in at least 24 counties in 2012. Now, in 2010, it was, quote, only 10 counties. But it's actually gotten worse in Iowa. It's gone from 10 to 24 counties. In Colorado, there are more people on the list than are eligible to vote in at least 22 counties, and that compares with 2010's number of only 10 counties. Frankly, anything more than one is a problem. In the District of Columbia, both in 2010 and 2012, they have, obviously there's only one entity here in the District of Columbia. They have more people on the voting rolls than are eligible to vote. I think it's 100% of the voting age population is on the voting roll. So I don't know how that's working here in the District of Columbia. The Judicial Watch letters also to Iowa, Colorado, and D.C. asked that they respond to the notification letter within 45 days of informing us of being informed of the complaints, and we want to know what the compliance steps they are planning to take. Specifically, we ask that they conduct or implement a systematic, uniform, non-discriminatory program to remove from the list of eligible voters the names of persons who have become ineligible to vote by reason of a change in residence, complete this program no less than 90 days prior to the November election, conduct or implement additional routine measures to remove from the list of eligible voters the names of persons who have become ineligible to vote by reason of death, change in their residence, or disqualifying criminal conviction, and to remove non-citizens who have registered to vote unlawfully. And those steps they can take to, and I trust the lawyers will correct me, but they can take that up to the election day. Of course, in its letters to California and all these other states that I talked about where we're asking for information, we're warning them that they must conduct a general program that makes a reasonable effort to remove the names of ineligible voters from the official list of eligible voters, including, again, voters who become ineligible by reason of death or a change in residence of the registrant. Accordingly, we ask that you please respond to this letter to address the apparent problems, as well as to what additional steps the state plans to take to ensure its voter rolls are current and accurate in light of the problems that we've highlighted to each of the states. Judicial Watch's notification letters and letters of inquiry are part of its continuing election integrity project, which includes pushing states to comply with Section 8 of the NVRA, which requires that reasonable efforts be taken to maintain accurate voter registration lists. Judicial Watch, along with its co-plaintiff True the Vote, filed historic lawsuits against Indiana and Ohio under Section 8 of the NVRA already. And in January, Judicial Watch and True the Vote reached a settlement in our August 30th, 2012 lawsuit against election officials in the state of Ohio, which resulted in an agreement by the state to take a series of actions to further ensure that it is in compliance with the MVRA. You know, dirty voter rolls can mean dirty elections. Many states are shirking their legal responsibilities to maintain clean election rolls. This undermines confidence in our election system, and outrageously, the Obama Justice Department simply refuses to enforce the federal law that requires states to take reasonable steps to clean up voter rolls. Judicial Watch is now doing, outrageously, the job of the U.S. Department of Justice. So with that being said, I'll turn it over to Bob Popper and Chris Fideli if they have any additional comments or clarifications of anything I said, and to certainly to talk about, Bob is the former deputy voting chief of the former deputy chief of the voting section of the U.S. Division of Civil Rights at the Department of Justice. So I'll turn it over to Bob.
Well, I'd like to amplify something that Tom said. I did work at the Justice Department. I was hired in 2005. And in the last 3 years of the prior administration, we commenced, I was part of 5 lawsuits in which it was alleged that the list maintenance provisions of Section 8 of the NVRA had been violated. In the 6 years of the Obama administration, there's been not a single lawsuit. There has been, to my knowledge, a demonstrated lack of interest in the Justice Department in pursuing these lawsuits. And in fact, the one claim that had anything to do with list maintenance coming out of this Justice Department concerned a lawsuit that it commenced and then lost, in which it tried to force the state of Florida to stop removing non-citizens who were on the voter rolls in the run-up to the 2012 elections. Other than that, the Obama administration has no interest in pursuing Section 8 lawsuits and list maintenance lawsuits. Arguably, that makes Judicial Watch the #1 institution in the country pursuing these kinds of claims. It should be the Justice Department. It's not.
Chris, did you have any clarification on any of the numbers? You know, just to be clear, when the motor voter legislation was passed during the Clinton era, you had Section 7, which encouraged states and required states to make available and make it easy to register to vote at DMVs and places of where they obtain public assistance. But obviously, when you had large numbers of people coming onto the rolls, you also had to have systems in place to make sure those rolls were clean. And the compromise there was Section 8. Section 7 is being vigorously enforced by the left and by its allies, obviously, in the Justice Department. Section 8, they are hostile to. It's clear from published reports about the views of Justice Department officials, and certainly the facts are that nothing has been pursued as it relates to Section 8, but plenty has been pursued as it relates to Section 7 of the National Voter Registration Act. So the proof is in the pudding here. The Obama Justice Department refuses to enforce the law, and it's leading to dirtier and dirtier election rolls. Excuse me. In Colorado and Iowa, things have gotten worse. In the states, the dozen or so states we had referenced in terms of sending letters of inquiry asking for more information, we're not asking that for information just because we're curious. It's because there are indications in each of those states they have more people on the rolls in many of the counties than are eligible to vote. So if you're over 100% of your list in terms of your eligible voting age population, that's a pretty easy case to make. Certainly it would seem to me to the courts, and administratively you ought to be looking at things very carefully internally if you've got more people on the rolls than are living there. And it's really inexcusable in this day and age for the list to be as dirty as they are. We have an election in District of Columbia next week. We can't have confidence in the integrity of that election as a result of the mess that the district's voting rolls are in. And it's not too late for the district even to take steps now, at least to make sure that, for instance, dead people aren't on the rolls. When you have these dirty rolls, when you have people on the rolls who aren't supposed to be there, that's an invitation for voter fraud. Because people can vote in the names of those individuals, or certainly people who move away and maintain their registration can vote twice in 2 different jurisdictions as a result. One, certainly in this age of mail-in ballots and easy absentee ballots, that's where you have rife opportunities for voter fraud. So it's about time that the Department of Justice get its act together, but in the meantime, Judicial Watch, as I said, is prepared to engage in additional litigation. I can tell you that the litigation we filed in Ohio and Indiana with True to Vote was the first of its kind by a private party trying to enforce the law, the federal law, that the states take reasonable efforts to clean up the voting lists. And in Ohio, we had the extraordinary agreement that led to some major improvements in the list maintenance procedures in Ohio that will benefit the elections in 2014 and in 2016. Indiana, unfortunately, we're still in the midst of litigation there, but we're confident that the courts will find in our favor as well, because Indiana hasn't been complying with Section 8. But as I'm telling you here, you can see that there are more than just 3 jurisdictions or 3 states we ought to be concerned about, and this is why the Justice Department really needs to get on the ball here. So with that being said, I'll open it up to questions, unless you have anything to add. Any questions or comments? Yes, Fred?
Thanks. Thank you. As far as this goes, this is more of a technical question, I guess. But once you take these to a lawsuit, is this going to require like a plaintiff in each of those states, Colorado, Iowa, D.C.?
What we did in 2012 is we sued as Judicial Watch on behalf of our members registered to vote in those states who are going to suffer an injury.
Any other questions? Okay, well, thank you very much for coming out today. Appreciate it.